On Monday, Donald Trump signed an executive order seeking to redefine the meaning of the 14th Amendment and end birthright citizenship in the United States as we know it. The 14th Amendment, one of the since called Reconstruction Amendments, was adopted in 1868 to clarify U.S. citizenship and equal protection under the law. As continues to be the case today, as evidenced by Trump's actions against it, the amendment was hotly opposed by Confederates and the former Confederate states who wished to maintain their legal right to discriminate against and subjugate non-white Americans and or Americans they felt weren't deserving of full citizenship. Trump's executive action, like many of the policy goals of the Republican Party, are a continuation of that effort. The issue in dispute is the Citizenship Clause of the amendment, which begins, quote, "All persons born or naturalized in the United States and subject to the jurisdiction thereof are citizens of the United States and of the state wherein they reside," end quote. The question being whether the children of foreign nationals are subject to the jurisdiction of the United States. Importantly, this question was addressed directly during the time of the amendment's passing, specifically regarding the children of Chinese immigrants. For example, then Senator from California, John Conness, said during the amendment debate, quote, "The proposition before us relates simply in that respect to the children begotten of Chinese parents in California, and it is proposed to declare that they shall be citizens. I am in favor of doing so. I voted for the proposition to declare that the children of all parentage, whatever, born in California should be regarded and treated as citizens of the United States, entitled to equal civil rights with other citizens," end quote. And before you write that off as the words of a woke sanctuary city radical leftist, John Conness was a Republican at the time, and he said this in 1866. And this is what might be the most important thing when it comes to the relationship between the 14th Amendment and birthright citizenship for the children of undocumented immigrants. See, undocumented immigrants wasn't really a thing when this amendment was ratified. Gaining legal residency in the United States was exceedingly easy back then. You basically just showed up at a port of entry and signed a paper. And while it is true that the primary impetus for the 14th Amendment was to eliminate doubt about the citizenship of people who were born in the United States enslaved, it's equally true that the spirit of the 14th Amendment was the same as the Reconstruction Era itself, which was to make more true the American claim of equality, to make more true the idea that everyone born in America is equal under the law. The amendment and debate around it at the time was not limited to African Americans, as the executive order erroneously attempts to claim. While anti-immigration activists have long pointed to the section of the clause subject to the jurisdiction thereof as a reason to deny citizenship to people born in the United States to undocumented immigrants, the court and the legislature has never taken that idea seriously. Federal courts have long treated the children of undocumented immigrants as citizens. The most famous Supreme Court case on this subject, U.S. v. Wong Kim Ark, actually specified when birthright citizenship wouldn't apply to the children of foreign nationals and singled out the children of foreign diplomats, completely ignoring the legality of the parents' residence in the country. So when this executive order claims, quote, "The 14th Amendment has never been interpreted to extend citizenship universally to everyone born in the United States. The 14th Amendment has always excluded from birthright citizenship persons who were born in the United States but not subject to the jurisdiction thereof," end quote, it's lying. It's pretending that subject to the jurisdiction thereof means legal U.S. resident, when in actuality it means not subject to foreign jurisdiction, as is the case with foreign diplomats. But separate and apart from all of that is the question of whether a president can unilaterally reinterpret the Constitution via executive order, and given that the framers were very careful to separate powers through a system of checks and balances specifically to disallow the executive branch from doing that, the answer to that question throughout U.S. history has generally been no. Thus enters the chat federalism. 22 states, the city of San Francisco, and Washington, D.C. have filed 2 lawsuits, one in Massachusetts and one in the state of Washington, to block this executive order on the basis that birthright citizenship has never been ruled to exclude the children of undocumented immigrants, and that neither the president nor Congress has the unilateral power or authority to amend the Constitution. It's important that these lawsuits are happening. Not only is this executive order entirely unnecessary and without benefit, it would also create a lot of problems. As Attorney General from Washington State Nick Brown articulated, quote, "It would render these children undocumented at birth. It could even render them citizens to no country at all," end quote. But of course, as with everything Donald Trump and the Republican Party does, causing problems is the whole point. For now, the order has been blocked by federal Judge John Coffner, who was appointed by Republican President Ronald Reagan. Judge Coffner said about the case, quote, "I have been on the bench for over 4 decades. I can't remember another case where the question presented is as clear as it is here. This is a blatantly unconstitutional order," end quote.